Okay, so Craig, I'm gonna mute. We got about 4 or 5 minutes. We'll let people jump on. I'm gonna cut my video, mute. I'll be back in like 3 minutes.
Yep, I'm going to do one final pit stop and be ready.
All right. Hi, everybody. This is Paul. We're waiting for Craig here to jump on. Craig, are you there? We're going to get going here. Make some introductions. Well, I'll start by saying I want to welcome everybody to this episode of Wealth Protector TV. And the law firm is Barth Calderon, and we put on these live shows, and the big focus is on education and providing high value content that can help you in some way. And so we're excited about this presentation, which is all about estate planning. And all of us hear about estate planning along the way, but we want to make sure that you understand exactly what an estate plan is, what goes into it. And then we thought it would be great to give you a behind the scenes look at what is involved in setting up your estate plan, the mechanism to do that. And we're going to take some Q&A at the end. Please feel free to type your questions in the chat feature along the way. If you think of questions about your own plan, or maybe you're advising others, maybe you're an advisor, a tax professional, wealth manager, or whatever the case may be, and you're thinking of your clients, please type in any questions you may have, and we'll get to as many of them as we can as possible at the end here. We'll leave a few minutes, and I've got some emailed questions in already. And then if anybody has a desire to get one-on-one with us as a follow-up to this, I'm going to put in the chat feature here, once we get started, a link where you can schedule a one-on-one call with the team and get with Craig to address any more personal specific questions about your estate planning. We do have a complimentary assessment that we will do with everybody That's free completely. So take advantage of that. Craig, welcome. Oh, you got to unmute yourself.
Yeah, and I had to turn off all the music, in the background.
Disco music, I'm sure.
Exactly.
So yeah, thanks for being here. Craig is a paralegal with the law firm Barth Calderon. So he's, a man in the trenches with the attorneys and the team doing the estate plans and collaborating on those. So Craig, I want to jump into this. First of all, let's get into the overview of what exactly is an estate plan. It's this lofty title. You think of Warren Buffett and Bill Gates, but we all have an estate at some level. So tell us what is the definition of an estate plan?
Now, it's always the big question, why do I need one, or what is it? The first thing that people think of is their personal property, their real estate, or their IRA, and who gets what, right? And the real overriding definition of an estate plan is literally everything that you might leave behind to family or to charities, or anything that you have that ultimately has to be dispersed to people that you might leave behind. That's the first kind of overriding definition of the estate plan. It really covers all of those things. But the estate plan itself is more than just who gets your Star Wars commemorative plate collection. Okay. It really should include a variety of legal documents that I like to call the legal toolbox. Your legal toolbox really needs to have all the appropriate tools so that whoever you put in position to help settle up your affairs has all of the legal tools they need to get it done.
Okay, so the estate plan is the assets that are covered in your estate plan: property, a business, stocks, bonds, and cash at a certain level. What goes into that estate plan?
That's actually that's a very important detail you bring up, Paul. That a lot of folks will think big picture. They think, of course, maybe real estate. It's interesting that sometimes business owners miss a very important detail, and that's the ownership interest they may have in a business or income real estate or a partnership where that is not properly attached to the estate plan. We'll talk about that in a minute. I'll mention trust and estate funding, but I think might be an important place here just to go over what actually should be in the estate plan toolbox so that you have a comprehensive estate plan, and what does that entail, right? Yeah. So maybe I'll just go through a quick list of those and we can break down some of the details in.
Yeah, okay? Let's go into it.
Number one is every good estate plan should have a will. And a lot of folks will stop right there and say, well, if I have a will, why do I need anything else? I've got it covered. Well, a will in and of itself is simply a list of instructions for the probate court, for example. It just says, this is someone who passed away. Here's a list of what they wanted to happen. And your family still ends up having to go to probate with the will. So the most important piece to connect the dots in an estate plan is the revocable living trust. So the revocable living trust works hand in hand with the will, so that the living trust itself will own assets, will have assets assigned to it, so that now there are no assets to go to probate because the living trust bypasses probate.
And probate is the nasty experience where the courts get involved and there's statutory fees. It can take forever, and it isn't always a pleasant experience. Fair comment?
I've never heard of it described ever as a pleasant experience. The first time I ever met anybody that had suffered through probate, they said yes to a neighbor who listed them as trustee on their estate, and they passed away. And that neighbor now managed almost 3 years of probate here in Southern California.
Yeah, nasty. So
yeah, it was not good.
And I was going to say, doing the will doesn't keep you out of probate. The living trust is what keeps you out of probate.
Right, right. It's a very important connection. A lot of folks don't understand the difference. It was described to me by an attorney many years ago that a will is simply instructions to the court for what to do with the assets of a deceased person. Now, a living trust, on the other hand, is essentially an entity. It's an entity that does not die. And if probate assets are the assets of a deceased person, and we make sure that our living trust controls all of our important assets, and there's no assets of a deceased person, no probate.
Okay. And so the will, I want to comment on the will. I've heard you mention pour over will.
Yes.
And so what's the pour over will? What type of a will is that?
It's generally built into a comprehensive estate plan. And what it says is that if we missed something, right? Let's say that a family missed a valuable asset, and I've met folks that this has happened where folks have had a collection of some kind and they did not properly identify it in their revocable trust. And now we're trying to sell a car collection or something like that. And that's an asset that may have substantial value that a probate court could get very hungry about. Now, the pour over will says, whoa, whoa, whoa. Everything we have was intended to pour over through that revocable living trust. Even if we missed it, we intended to. Everything that we have pours over into that estate plan so that we can use that to avoid long-term entanglements in the probate system.
Okay. Great explanation. So then going back to what goes in the trust, you got a business that needs to be accounted for in the trust, right? No matter what that business is, if you own a business. So
yeah, absolutely. That is generally an assignment that needs to be done. The attorneys in our firm actually do this all the time. These are assignments of company ownerships and partnership interest. They really do need to be connected properly. I've met folks that have very valuable assets in the form of LLCs and S corps and C corps, and they did not properly connect those to their revocable living trust in their estate plan. That's some pretty substantial value sitting out there that the courts could get a hold of. So we often will fix that very easily with our team.
And one of the pitfalls that I know we talk about for a business is if you're in business with somebody else, you own a property, you own just a corporation, and that person doesn't properly have that business in their estate plan and it gets probated, guess what? You're in business with your business partner's probate process.
Yes.
And assets could be frozen. I mean, it's a heinous scenario. And
it absolutely is. Had that conversation. Absolutely had that conversation just before Christmas with some folks. Real friendly business partnership. Everything's happy. It's great. They're running a successful business. And they didn't realize that because they have a full estate plan and their partner didn't, that there is substantial risk of probate if something happened to that partner, or if that partner was incapacitated and there's no provisions for anyone to manage that person's finances as a partner in the business, that could create really serious problems.
That's a problem. Okay, so we got the business. What about rental property? So got to account for any property, your home, not only rental, but your home, right? In the name of the trust.
Absolutely. The property piece is one of the biggest mistakes that's made in funding an estate plan. So I mentioned that word earlier. Funding an estate plan is really making sure that assets, first of all, of substantial value. And what does that mean? Usually real estate, more than $50,000 to $100,000, physical real estate with a foundation and a tax ID number, that really should be titled in the name of your estate plan, your revocable living trust. And we see it so many times where folks will go through a refinance. They'll buy a home, sell a home, whatever they might be doing, and they miss the critical detail of putting that property back into or connecting it back to their living trust. And we see this with LLC partnerships and in investment real estate as well, where large scale investments don't get properly connected back to the estate plan.
How does that work with an LLC, Craig? So if you have an LLC and you need to connect it to your living trust, is the LLC referenced in the trust? Is that what happens, or?
Really, there's actually something called an assignment of interest. It's a document that's filled out, and I personally, I would never want to do it myself, because the language in a parcel description and property description is so important for the legal protection of assigning it to anything. I would always suggest having it done. We have some great attorneys that do that specifically, and you assign interest in a company or an LLC that you may have a partnership in or an ownership interest, so that it is officially connected to the estate plan.
So you assign the LLC interest to the living trust.
Yes,
Meaning,
absolutely.
Meaning it's mentioned in the trust.
Yes, it is specific. It's specifically connected with legal documentation so that it's official. You want to make sure those things are, you want to memorialize that on paper with the notary stamp and all the official accoutrements.
Okay, all right. So whether you own the property outright or you've got a partnership in it with somebody else, whatever your interest is in that property, 50%, 10%,
Right.
1%, you're assigning that into the, okay, got it. All
Absolutely.
right.
Yeah.
Stocks, bonds, and cash. What's the recommendation for, you got an investment account, you got the bank account, if there's $50 in it, not a big deal maybe, but what if there's more money in there? What do you do?
No, it's a great question, Paul. A lot of folks miss this. They think stocks, bonds, and cash, or just cash in general. Folks don't understand the real risk, the asset protection risk that goes with this. That if you have a substantial amount of money, and that could be 50,000 or 100,000, I've met folks who have inherited money and then were nervous about doing anything with it, so it just sat in their bank account, and they didn't realize that $490,000 in a bank account was at risk of lawsuits from anyone that might try to sue them. So we will often suggest using a stocks, bonds, and cash limited liability company to wrap around that asset and protect it and make sure that we have as much protection as possible from outside creditor threat. Now, the piece that is missed many times for folks who do this DIY, where they just go online because they heard it on the radio, they miss the connection to their estate plan. It needs to be assigned properly to the estate plan, or that asset, that LLC with lots of cash, could get pulled into probate.
Yeah, and Craig, banks are used to this all the time because, meaning for my own use, with the LLC, my family, but you go to Bank of America, well, whoever you bank with, and they set these up all the time. It's an account, checking account. You got a debit card, a checkbook, with the name of your LLC or trust. So
absolutely.
Not a big deal there. And then, okay, so we got the business, the property, stocks, bonds, and cash. Anything else we're missing?
No, I mean, it is. Some folks will say, should I put my car in there? My car is worth a lot of money. Well, what's a lot of money, right? So that's a question. I'm a big car guy, and I get this question often. If you own a one-of-a-kind Ferrari that you found in your grandpa's barn in Montana, the Ferrari should probably be in its own limited liability company and connected to your living trust. If you own your favorite 1970 Ford El Camino, you might just write that as a note on your gifting list in your estate plan. You don't necessarily have to title it in there, but that's a question to ask, during an assessment. Hey, these are all the assets I have, and what should we do with them?
Yeah, well, that's interesting because it brings to mind a case we were working on at the firm where a couple had, I believe, was the largest in the world collection of Star Wars memorabilia. And
yes.
They were, they were divesting themselves of it, but I mean, worth millions. And, that's something that obviously would be part of an estate plan in your
it really should be. It should be a part of many different conversations. I've met some folks with, for example, in my car, background, with just millions and millions of dollars in cars that these folks collected, when they weren't worth that much, and they had never actually protected them correctly or connected them to their estate plan. And that's a juicy asset for the probate courts.
All right. All right. Let's get into the mechanics of actually how this happens and how you execute on this stuff. So let's walk through this. So a single person, a couple, and we can talk about the difference between a single person and a couple in a minute, but they said, okay, I'm going to finally get my estate plan done, right? Brand new year. Let's do this. What is the first thing that happens? Step A.
The first big consideration, right? Aside from, do I actually want to get an estate plan?
Yeah.
Okay. And let's say that we've gotten past that part. We love our family. We love our children. We love our charities. We don't ever want anybody left behind to get tangled up in all that probate nonsense. So we're going to get an estate plan. Got that. The first big thing to consider is, who will your representatives be? Who will be in the various positions in the documents, in the various documents that make up a complete estate plan? Who will your representatives be? Choosing a person who has management over your checkbook when you're unconscious for a few weeks, that's a big deal, right? That's a big deal, because financial power of attorney, for example, they can talk to your mortgage company, your IRA company, they can sign your name at the bank, so that's a big deal. Choosing your representatives is a big one.
So step one, you're saying, is to start to think about people that would serve as your trustee and have financial power of attorney for you and authority over medical decisions, which all go into your estate plan. So what you're saying is, step one, start having this discussion. And let me ask you a question on that before we get into, okay, how do the meetings play out? So if you're thinking about those things, what are some of the important issues? Like, is the person that has the financial power of attorney for you the same person that has medical authority over you?
Oh, that is a very, very good question, and one that does sometimes get a bit sticky. But I'm going to mention something that first, as you choose representatives, geography is extremely important. So we have clients in the firm who live in Idaho. We work all across the country and met these folks through their CEO group, and we set up a new estate plan for them. And the wife, she wanted her sister to be her representative for medical power of attorney. Well, her sister lives in New Zealand. And that could work remotely through Zoom meetings and such, but what if sister had to get bedside? What if sister really needed to get bedside? Well, lo and behold, New Zealand's been on lockdown for a couple years. So the suggestion from our attorneys was to perhaps have sister listed as a backup representative, but perhaps choose someone closer to home. Right.
Oh, yeah.
And that was a first big step, was making sure that person was maybe a little bit closer to home, so they could get in there and help with, decisions firsthand.
Yeah.
Okay?
Yeah.
Yeah. So I don't know if that's it. That's actually a big one, is making sure that the choice. Now, should the person who represents you for healthcare be the same person who has financial power of attorney? In many cases, the answer is no. I've been in situations often where a husband would like his brother to be his medical power of attorney, and the missus would like her sister to be her medical power of attorney, or mom, because they feel more compatible. Yeah. Now, when it comes to financial powers of attorney, for a husband and wife, for example, for a couple, a married couple, then now you're in a situation where you may want to have the same person, because you're managing a joint household. That's a big decision. So that's one of the things that we definitely spend some time talking about on the assessment and the drafting part of the estate plan, is trying to figure that out.
And I want to answer these questions as they come up, but when we're talking about this with a blended family, can you have co-representation, meaning one daughter from husband and one from wife?
The answer, the answer that our attorneys give often is maybe and yes. Okay, so let me explain the lesson I learned about and or. The lesson that I learned long ago about and or. So if Paul and Craig are both brothers and mom and dad are thinking about who to put down as power of attorney, Craig is clearly more responsible than Paul, but they don't want to be, unkind to Paul. Okay, so they say Craig and Paul are our representatives. In the legal sense of things, some financial institutions use the word and they put Craig and Paul together. That Craig and Paul can only act together. They cannot act separately. If Paul is on a cruise, we need Paul and Craig together. The challenge with and is that it could perhaps be interpreted as those two have to be together lockstep. We do often see Paul or Craig, that type of a setup where we'll have representatives that they can work independently because we trust them both and they don't have to be in the same room to act in that capacity. So that is one way to do it. We often suggest, the attorneys at our firm often suggest choosing that first level, say Paul as the representative, and if Paul is unable to serve, then Craig would serve.
Yeah,
right? And then we go from there.
And I've heard a blended family is a great one to bring up. Because I've heard you and Brad, our attorney, speaks on this issue a lot, talk about blended families, and it's an important one because there's a lot of pitfalls with that. Because if you're coming out, whenever you get remarried,
right?
If you had an old trust, of course that needs to be dissolved and get rid of that.
Yeah.
But you need a whole new trust, and a lot of times, Craig, it's his, hers, and ours.
Right.
They're separate property, they're separate kids. So she has her trust that takes care of her with her wishes. He has his trust, and then they have a trust together.
That does happen. Yes, we see that.
But it may be all kind of encapsulated in one. Is that right?
Absolutely. We see that frequently. The biggest challenge in those situations, I feel, is situations where minor children are involved. When we have a young family, multiple children that are under 18 years old, now being able to manage things like guardianships and who gets what and beneficiary designations, those have to definitely be balanced. Again, part of that detailed assessment and all part of that drafting conversation to sort out the details.
Okay, so you can pick different people and have co-representation.
Oh, yes.
Got to draft it right. And on this subject of blended families, it's interesting because the most famous story is Marilyn Monroe married multiple times, and when she passed away, she had not canceled her old trust, where an ex-husband, I forget the guy's name, but he inherited the dress that she wore when she sang happy birthday to John F. Kennedy, and it was worth millions.
Right.
And he auctioned it off.
Right.
I think he put it on eBay or something like that. But the point is, unintended consequences if you're getting remarried and you don't update your planning. So very important.
Oh, yes. Yeah. The big one we hear about is, where someone didn't update their estate plan and left a former spouse as beneficiary. Oops. Yeah. Right. We got to make sure that gets fixed.
Okay. So step number one, as we talk about the layout here, is think about these relationships, who you're going to name. Now, you're ready to move forward. What happens? Is there a questionnaire that's filled out is there a first call? I mean, what happens? Get me into the gutter there.
Okay, no, good question. The first step, of course, is now we want it. Now we've kind of given some thought about who would be our representatives. We might have even talked to those folks to make sure it's okay. And then we have a assessment call first. An assessment call is just that. It's just talking through this conversation with the specific client, whether it be husband and husband, husband and wife, two partners, boyfriend and girlfriend. I mean, we see that all the time. Okay. But that initial assessment call first, just to talk through the process of what it might entail. And then the next step. So now we're on to the next step that parties involved say, yes, we want to get our estate plan done. Now we go to the drafting call. Now, we usually don't do questionnaires. We like to have a drafting call that might take 45 minutes, might take 70 minutes for us to go through all the pieces of the estate plan, and we talk through each of them. Instead of a static questionnaire, we go through and explain and dive into each particular question, and then we build out the answers to how the estate plan should be constructed. Once we do that, then we create a draft copy of the estate plan.
Hang on.
Go ahead, Paul.
Let me go back.
Yeah.
So I guess the questionnaire I was referencing is really an asset statement leading up to the first call. So you got to know what the assets are. So the questionnaire is an asset statement. Put down what you got, how it's titled, values, and all of that. That's obviously very important.
I see what you mean. I understand what you're meaning there.
Okay, so now it comes to this first call where you're diving in and going through step by step. That could be in person, phone call, or Zoom. Is that correct?
Absolutely. Yeah, absolutely. And we find a lot of folks actually have really appreciated our, we have a technology-based firm, and we do a lot of Zoom meetings where folks are able to meet from anywhere in the world. And we'll meet in person, we'll meet over the phone, or we'll meet via Zoom, whatever works.
Okay. So now you have that first strategy session there, and y'all talk, you get on the same page, you dive in, and then the draft goes out.
Yes.
Right? The draft. And does the draft go out by mail? Is it a digital copy? Is it both? What happens?
We can do both. If people want a physical copy, we can definitely do that. We generally will send out an email, a document link, so that they can open the document on their computer and review it. Just saving a few trees, because it's just a draft copy at that point.
Right.
And we'll send it out most of the time via email, where there's
what do you want them to do? What do you want them to do?
At that point, this is where some of the delays come from, right? At that point, what we really want the clients to do is open that document and just start reading through and reconsidering the conversations that we've had in the assessment and the drafting call. Make sure they still like Cousin Ed as the representative. Make sure they still like that charity as the beneficiary. Make sure they're still happy with the way they built their estate plan. And if they want to make any changes, they just let us know. If they want to change the name of their trust, we like to encourage our clients to come up with creative names for their estate plan, for example. And oftentimes clients will want to change the name, and they'll make a change on a representative or something like that nature. And then we adjust, we verify that it's ready. And then from there, we generate the documents that will need to be signed and notarized to start making everything official.
Hang on. So they got the draft out there,
right?
They go through it, and then now they make changes, sign off, tell you whatever needs to be done, and then you'll update it and create the final copy. Is that right?
Correct.
Final copy then gets emailed back to them, or maybe there's a discussion there, maybe there's some questions that come up. Final copy gets emailed back, and they have it. Is it recorded anywhere? Like, what happens? And
not yet. Yeah, not yet. So what we'll do at that point, once the draft is officially approved, we actually print a full hard copy ready for notary signatures.
Got it.
And that is mailed to the client, all tagged and ready. Now, depending on where the clients are, they can come into the office and we do the notary in-house, or we arrange for notary wherever they might be in the country. But that is a physical copy that goes out so that we can get wet signatures on all the documents. And then it comes back to us so that we can scan and record the signed estate plan. And then we prepare it for final mailing to our clients.
Got it. Okay. So the final product goes out after that. And then
Right.
how do we fund like property into the trust? How do we move that around? Like
No, that's great. It's actually one of the biggest mistakes that I always encourage folks to not do their property recordings on a DIY basis. It's really important to get updated deeds, transfer deeds, where we transfer a jointly held property into a new living trust. And in many cases, our final documents that we send out for notary signatures will include the transfer documents to move that primary residence into the estate plan.
Okay. So that gets moved in. And then I know, very important point is life is not static. People's lives change, laws change. We have changing laws right now going on. It's insane that affect a lot of people, laws coming out of Washington. And so I think a big focus point is ongoing the access to the team. I know at the firm, the service team, and keeping updated, keeping sticky with the client. That's important because we see a lot of people, they think it's a one and done, and then life starts happening and things get out of date, out of whack, laws change, they're not up on it. So I know you and the whole firm very good at staying on top of clients, educating and keeping them in the touch point ecosystem of the firm.
Absolutely. That's the thing, is that this is a revocable living trust. It is a living, breathing document that as long as you're living and breathing, you should always remember not to just leave it collecting dust. It should not be keeping your table level in the den. It should be something that every 2 to 3 years, or every time you've had a major change, or a new child comes into the world, or you buy a new house, or any number of things that might happen, those are times to say, should we have our estate plan reviewed? Maybe we'll get on the phone with Craig or the team at Barth, and let's just double check and see how things are going.
Right. Well, great. Craig, incredible information as always. Want to remind everybody, because a few people have jumped on late, in the chat there, I put up a link. If you copy that link, that will get you into the calendar one-on-one with Craig, where you can have a discussion about your own situation. And, we are not an hourly billing firm, so don't worry about getting charged. Leave your checkbook at home. This is just us providing value. Love to give you input on your own situation and address any questions that might be popping up. Link in the chat, and keep close to us because we're putting out a lot of content.
Yeah.
We're developing a ton of content. New year, new stuff going on. We want to keep you informed. Appreciate you being here on this episode of Wealth Protector TV. Craig, thank you. And I know we're going to see you again real soon.
You got it. Thanks, Paul.